All right, team, we are live. Now, today we're going to be talking in this first recording about this distinction between election, to terminate, or to affirm. And as part of that process, I will get the class to be somewhat quieter. Although you have to just bear with me, I'll bring it up on the screen. So, you might recall that we've already gone through some component of this last week when we looked at contracts and we looked at what the result is. Because fundamentally this is about the result that you get.
Sorry, have you started, Simon?
Yeah, it's the result that you get from obtaining a right. Now, you guys are aware that in contract law, at certain periods and certain points of time, you obtain a right to do something, to terminate or to not terminate. And the situations where that arise is when either a party has committed a breach of a serious term, a major term of a contract. We call those breaches of conditions, and when a condition, a major term in a contract gets breached, the innocent party gets a right to terminate. That's one situation, for example, where that comes up. You also get the same right to terminate when there is a serious breach of what we call an innominate or an intermediate term. That's a term capable of large and small breaches, and a serious breach in that situation will give the innocent party this right to terminate. And this other situation where it can come up is what we call repudiation. That is a demonstration from one side to the other of either an inability or an unwillingness to either perform all the obligations under a contract or to perform, or failing to perform one of the conditions still outstanding in a contract, or demonstrating an unwillingness to perform a series of warranties, a series of minor terms that in entirety is going to count like repudiating a condition. And so this topic, which is not particularly long, is us talking about what happens next once this right arises. What do we do as the innocent party, and also as the non-innocent party, which we'll get to in a little bit later. So there's a couple of things to note here. This is a right, it is a common law right, and it's fundamentally grounded in the idea that we want parties to sort things out themselves. Ideally, in a perfect world, we don't go to court because we know what the rights of the parties are in relation to each other. In a perfect world, we all know what the rules of contract are. It doesn't require adjudication. We want the parties to sort things out themselves, not have to go to court. We don't live in a perfect world, sadly, and so people get these things wrong. And so we will have to look at what's going to happen next, in particular in situations where one side thinks the other side is in breach or is repudiated, and they turn out not to be, because then you become the bad guy. So a couple of things to note, that when this right arises, you as the innocent party, when the other side is either repudiated or breached a condition or made a serious breach of an intermediate term, or in some situations where you've got an express term of the contract that gives you this right to terminate as well, you get the option. And so this lecture is talking about what do you do with this option? An option to either terminate, end the contract, or to affirm it and say, I want to keep this contract on foot. Keep contract on foot. On foot, yes, to keep it going and for both sides to continue performing their obligations. because well, an injunction is a remedy in equity. So the question there is, can you get an injunction to do that? The response is that an injunction is a remedy in equity, and equity will only intervene where common law remedies are inadequate in some way. And so we will talk about that later in this subject. But by default, equity won't intervene where, first of all, where the parties can sort things out themselves. Then even if the parties can't do it, where we can use the rules of common law and contract law to be able to get to a result. That's really what we're after. Now,
what was that quote again? Keep contract on foot and keep party that last bit.
So you want the purpose of this part of contract law is that we want parties to sort things out themselves. We don't want people going to court. And so these rules have been developed so that parties can go through and essentially self-help. In a situation you can terminate, and the other side, when this right to terminate arises, you can either choose to terminate the contract or to affirm the contract. And this lecture is about talking about those two paths that you get to go down at that point. And the idea of affirming the contract is saying, I want to keep this contract on foot so that we both have to continue performing. And look, there's some real business reasons to go down one path or the other. And you as the innocent party, you get to make a choice. And really, it's a business decision which way you're going to go down. And sometimes the facts are going to lead you down one path or the other in order to achieve the best result for you. And it sounds a little selfish, but that's kind of contract law, really.
When the innocent party affirms the contract, they don't get on the right to get damages, do they?
In any situation where the question is, I'm trying to record these onto the stream for Stephen and co. The question is, when the innocent party affirms a contract, can they still get damages? And the answer is definitely yes, because any breach of contract is going to give you the right to damages, even if they're only small. Even a very minor breach can give you nominal damages. And again, a breach of a condition and a serious breach of an innominate term can give you the right to terminate. If you elect to not take that right, you can still get the dollars as part of that process. Good question. All right, but just make note, and this is from Emma of the Uniting Church in Australia. A little bit complex in terms of the facts, but it's actually a case that you may come up with in tort and land law because it involves the sale of airspace rights. So there's a church and it has land above it, and if you're a central city church and there are other buildings around you, that can be valuable. You can actually go and you can sell that. And again, they were trying to enter into an arrangement to do that. But as part of the process, they needed to get council approval. And the council actually came back and said, yeah, we'll let you do this, but before you will grant it, you're going to have to fix your church up. It's a bit messy at the top. There's a bit of public health and safety things. So yes, we'll do. It looks like we're going to do this, but we can't do it until you've fixed your church up. And so these documents went backwards and forwards between the solicitors, the people seeking to purchase their rights, and the church, backwards and forwards. And the key thing to note here is that when these solicitors were arguing about whether or not this particular condition of the council would essentially render it impossible to go through and perform, and they were talking about whether they were ready and willing and able to perform at that particular moment in time. The key thing to note, the court said, I think this went to the High Court, that in situations where you have this right to elect to terminate, and there are some rules around it, which I'll go to, that if you do go and affirm it, and you say carry on, And that can happen in a variety of ways, through conduct or through words or actions. If you do that, you lose the right. If you go and you affirm a particular contract, you can't terminate for that same breach. That's the principle, one of the principles that came away from that. If they repeat the same breach again, then the same right to terminate will arise once more. But for one particular breach where the right arises, and this can be sometimes a series of transactions, it can be a little bit tricky to construe, if you affirm the contract and say, this is okay, we want to keep it on foot, you can't change your mind for that one breach. Yeah, it's that. Emma actually talks, Emma and Uniting Church, they talk about a variety of principles there. So there's a few others. It'll pop up about 4 or 5 times in the course of this lecture. It is logical. A lot of these things are. And again, when you get to rules that are, so the question is, that seems very sensible, it seems very logical and commonsensical, and I agree, I wholeheartedly agree. A lot of these rules involving self-help remedies are commonsensical. They are things where, if we think about our society more broadly, we don't want people to be able to reach a situation where the other side's not going to perform, and having to turn up on the day with all of your tools and all your equipment and have everything ready to go, even though you knew that the other side, the boat was still in Perth, or that the person had died, or that there was some reason that you knew that they weren't going to be able to perform. We don't want the inefficiency of having to do that. We want parties to sort things out without needing to go near the court system. It can be done in a variety of ways. I'll get to that. There's a full lecture on it. But just in case I want to know, is that there's the plasticine case. It's fun, it's just interesting when I read this, because Wayne's Tank and Pump Company sounds like Bruce Wayne, because this involved a plastic manufacturer. And look, this is a pretty rare situation. They said that in terms of this right to terminate or the right to affirm, in terms of the election, there can be some factual situations where none of these rules are going to apply, because the contract in its very factual nature has come to an end. And so there it was a contract in a factory to install some pipes, and the factory blew up. It just blew up. There was plasticine and things everywhere, and the entire thing was essentially just a huge big mess. And of course the pipe guys, they're talking as to whether or not this is repudiation or whether they could affirm it and things like that. So look, in some situations, the facts are just going to end the contract. And this is different and distinct from the doctrine of frustration, which I'll talk about in the second half today. In some situations, it is going to naturally end. Okay, some people up there on the screen. Yeah, and that's right. I actually quite like that. The word election is a little simpler than termination. Should be termination or affirmation. It's really about the times where things will get the right to end the contract. Sometimes, though, strictly speaking, we'll get the right, but the facts will just jump in. It's quite a rare sort of situation where the facts will jump in and something like Harvard's plasticine, and that will just end the contract for us. There's no right either which way. All right, so a couple of things to note. Going back to Emma again, a couple of other things about Emma. It involves solicitors and this council condition, and so that there was a delay and they'd missed the settlement time and date, and so that one side wanted to terminate, and the other side found out that this council condition was never going to be met anyway. So what does that mean? It means you're unable to perform your side of the bargain. And the court, again, is one of the principles that came from Emma, said that, well, that may be the case. It may be the case that there are worse and factual things that prevented one side or the other from doing that. But in order for you to actually elect to terminate, it has to be done willingly or willfully. You have to know about it. It's got a mental component to it. There's active termination. And you actually have to know that you have that right. You can't just deduce it by the facts, going back and retrofitting this. Oh, at this particular point in time, the facts suggest that I terminated. That's not how this works. It has to be a willed, I should say, action. That's Emma again, because again, the information about the council condition wasn't known to both parties, and so they're trying to argue that there was this right to terminate. So well, no, Emma and United Interest. Yeah, if there's multiple, it comes up multiple times. Okay, and we had in the tutorial today, we had something along this line. We're actually going and stopping the other side from doing something is going to amount to an election to terminate. So they're in a situation, and again, we think of the tube question today, where we had a gardener, I think he was, a landscaper of some sort, and he got locked out. So the gardener gets locked out. Hey, we had a 12-month contract, we've done this for 6 months. We've now been locked out. They've taken away our pass code. We have been directly and overtly prevented by the other side. Now, if the other side is turning around and trying to argue that they didn't intend to terminate the contract, even though for whatever reason the gardener might have breached some condition, they can't do that. If you're actually stopping the other side from performing and you had the right to terminate, you are demonstrating at that point in time that you are using that right if you're stopping the other side from performing. Vital and Norelf, that was a shipping case. Now you'll note with shipping cases, or admiralty cases they're called, they often have the boat after them, and I've noted some of them, and I'm going to try and put the names of the boats in there, because it's always quite sweet when you see the boat's names in it. Why? Because the British common law system and contract law flows from ruled Britannia. England and later Britain, the United Kingdom and Britain, it's a maritime power. The British Empire was founded on its naval might. And so the cases that flow from contract law are not often, but substantial ones, can be cases involving boats. It's all around boats. The British were very good with their boats. Because if you think about it, England's a tiny little country, but huge on trade. Being able to trade things all around the world and to maintain and manage those things. And you guys are kind of fortunate in that you missed me teaching Contract 1, where I start to wave my arms and talk about the history of the British Empire. You dodged a bullet, it's fine. But it is, these admiralty cases, they do come up from time to time, and in your AGLC you're supposed to map them out there as well. So here, the Santa Clara. Either way, it involved LPG, where there was a boat coming to collect some LPG, and there was a breach, but at a point in time where the boat wasn't going to turn up, you've got the LPG vendor, you've got the boat to come and collect the LPG, they're not going to be able to turn up, so they're repudiated, this had the right will arise to terminate. And so they went and on-sold the LPG. All right, and then the boat did turn up, and the other side said, what's the story? We're here now. And they said, and the guys with the LPG that had on-sold it tried to argue that they didn't actually, we didn't actually elect to terminate, we just on-sold it because we didn't think you were going to go there. And the courts, this is the British courts, said, the House said, no, you going and on-selling that LPG to a third party is going to demonstrate that you are electing to terminate the contract. LPG, gas, yeah, propane, LPG, gas, yeah, natural gas. Look, I apologise to those that know the difference between those things. Compression levels, number of carbon atoms. Yes, yes. Because it's the point in time where we're either keeping the contract afoot or ending it. And if the contract is ended at that point in time, we're going to be seeking compensation. And we'll do going to do a full lecture on these compensation principles. And yes, you do owe a duty to minimize the defendant's loss by taking reasonable steps. Here, though, part of the process of doing that, and remember these are self-help remedies, the parties don't, strictly speaking, know or really, they're not the courts themselves. So they think they're in a certain role, or they think they're in a certain position. At this point in time, the boat wasn't going to turn up. We're going to on-sell the LPG. Particularly relevant if we're going to get a better price for it. And so sometimes, if we step back and think about commercial reality, sometimes we are wanting to on-sell things and we want this contract to be terminated. Other times we want it to be held on foot and get the other side to turn up and perform. We as the innocent party get to choose one way or the other, and we pick the one which is best to us. Sometimes though, we pick wrong, and there, in terms of doing this, when the boat actually did turn up on time, and the other side who've on-sold this LPG, they're going to be in a little bit of strife. They thought at that particular point they were doing and having election to terminate at that point in time. And so you've got, you can go either way at that particular point in time, because the election to terminate or not terminate determines whether or not you're carrying on with the contract. But it doesn't change the fact you're still going to get dollars for breach. All right, so that breach. So being wrong when the other side turns up, it's going to significantly impact the amount breached if they didn't actually breach at all. Whereas you as the party that's terminated are going to be in breach. So that can impact those things. They're two sort of different things. We'll spend some more time doing the calculations, because for those with a bit of a mathematical mind to these things, it can be quite interesting and very unintuitive. It's really scary when you start to work out contract law damages, because people don't know how they work. I'm not sure what happened in this particular case. For whatever reason, the facts suggested they thought the boat wasn't going to arrive in that one. I'd have to go back check in terms of notice.
So was it a commodity contract where the contractor delivered
Yeah.
this time,
Yeah.
this quantity
Yep.
at this price?
It was,
That's
yes.
what was said.
So the question is, it was a contract to deliver a certain quantity of goods at a certain time in a certain place? Yes. Yeah, it's a contract for the sale of goods. Where you're dealing with large entities, this is where the rules of common law play a far greater part than with smaller transactions, because shipping companies, mining companies, these multinational entities have a lot of power. They have a lot of bargaining power, and the transactions they are doing are large. And when you've got large, powerful players with these contracts, the gloves are off, essentially, and they are using the principles of contract law of ye olde England in order to map out these arrangements. Also with boats, one of the really kind of important historical rules, and it's, even though I try not to digress, but it's an important historical rule, is that you would have ship owners, shipping companies, and merchants from all over the world over the last 400 years, maybe 300 years, choosing to have their disputes heard in the British courts. So even though you might have two boats, a Greek dispute with a Turkish company selling to North America or whatever, it was quite commonplace to go and have the forum to be the British Courts of Admiralty. Not because either side would get the best result, but because the rules of evidence were well developed, and both sides would know that they would get a fair hearing in terms of doing those things. And that's why you will find these things will sort of come up, less so these days, but historically it's been a real thing.
Very hard to get access to those overseas cases. I was doing the last assignment and stuff like that, but they're international cases that don't seem to be on. So like when I looked up some of the cases that have had our legislates like Lions and stuff like that, I wasn't able to access that.
Okay, the question is finding UK cases, and yeah, there is a little bit of a trick with some of those. Sometimes you can use Bailey, which is the British and Irish equivalent of Ostley, B-A-I-L-I-I. It's online. It's the equivalent of Ostley for UK cases, but they're not all in there. But you will find a lot of the famous ones are. So you may be able to do that. Just use the citation, the AC citations. That can be a good place to start. What you find is that there seems to be an inverse relationship with the ease of use of databases and the amount of stuff you can get out of them. So the easy ones to use don't have the obscure things. And so you used to have these horrible moments. You have to go into the international LexisNexis database, which is hard to use, but it has the most stuff. But so another day. All right, so if you terminate, what happens? Well, at that point in time, your obligations from that point in the future for both parties lapse. So future performance is discharged, but present obligations remain. If you are obliged to do things at a later date, you do not have to do those things. If you were obliged to do things in the past and you haven't done them, you can still be sued for breach in regards to those. You are still liable to perform those things. And the key one is payment. So just make note. Look, it's one of those things I found I had a hard time getting my head around as a law student, sort of early on, is some of these rules that appear harsh. All of the money sits over here, or the contract is frustrated, which we'll talk about later today. Or it's terminated, and this side's got both the stuff and the money. That is not to say you can't use other principles to get a result in terms of getting your goods back. For example, if title doesn't pass, the goods are still yours, and they don't return them, use tort. Remember what the tort is? If you've got an immediate right to demand possession of goods that belong to you, what the tort is the tort of detinue. You can use that remedy to get your stuff back. You can use principles of equity and restitution to get money back if it's been paid accidentally. If somebody has your money, well, you can ask for that money back, and there's an order the court can do that. The similar thing can apply, I think, at the very, very end of this lecture, we talk about where there's a total failure of consideration. There's no contract. But so don't think that just because the money's sitting in strange places, that's not how the law ought to work. Often it does work that way, and people have got to use other areas to try and get stuff back. Right, and as always, breach of contract, always get the right to sue for damages, even if they're only nominal. Now, there are some special types of terms that will carry on. And so the main one that we need to know about are restraint of trade clauses. So a contract which is terminated, if we think about this, an employment contract or a small business, if you're buying goods off somebody or they're supplying with services, unique sort of services, you can put a restraint of trade clause into there saying you won't go to compete against me in Townsville for a certain period of time, or in geographical area, certain period of time. That's a restraint of trade clause. Now, clearly, those clauses are going to survive termination. So even when the contract is terminated, the restraint of trade clause is going to carry on, because we'd be crazy if it didn't. If we have an employment contract and it's terminated, and there was a restraint of trade clause, it's going to have to survive our contract. That's just that's the nature of the thing there. So even though that is, strictly speaking, future obligations, they will survive termination. Restraint of trade clauses. Does that make sense?
I think that makes sense, because when you're employed to be working in an accounting firm and get sacked, you get
exactly.
that you can't do something with the people that you've had as clients.
Yeah, absolutely. So the question there is that if you're working for a firm, a professional services firm, like an accounting firm, you can have special clauses in your contract that says you won't go and work for the competitors. And again, usually they're specified. Restraint of trade clauses are unusual beasts, and that they're often expressed many, many times in a contract. And the reason for that is that the courts will remove or just strike out unreasonable ones. So for example, if in the accounting firm, if you are not to work as an accountant for 25 years anywhere in Australia, all right, might be the first one. If Clause A doesn't apply, Clause B will say you're not to work as an accountant anywhere in the state of Queensland for 20 years. That struck out. Clause C will say you're not allowed to work as an accountant in Townsville in the next 15 years, or North Queensland in 15 years. And then the next one will be 5 years, and postcode 4814, all the way down to the very, very weakest form, because the courts will literally go through unreasonable, 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 just go through them until they reach a point where they say, okay, this one is going to stand. That's how those things operate, because restraint of trade clauses can't be unreasonable, and so you want to give it a go. You want to try and map that out, because the courts can be a little fickle in terms of those things. All right. Okay, now, last semester, you guys would have been exposed to the concept of estoppel. It was the first of the equitable principles that you're exposed to, and in fact, it's part of your entire legal education, which is a shame because it's really hard. It's one of the hardest areas of equity to really get your head around, and it's kind of unfortunate that you do that at the start. But here, equity will intervene to stop people from terminating. And it falls under that idea that it's where there's been some sort of promise that's been made by one side to the other that they're not going to rely on their strict common law rights. Equity will intervene to stop them from doing this. And in this situation, to stop them from terminating. And again, that's that situation where the other side, after this promise has been made, is where they've materially altered their position in reliance on that promise. The promise was reasonable, and in situations where it would be unconscionable for the side to, with the right to terminate, to do so. The question was to do with nursing homes, elderly nursing homes. Nursing homes, unfortunately, very, very unfortunately, are very big businesses these days. And so while I don't know the specifics in terms of nursing homes being in the news, it would not surprise me if they have very, very well mapped out contractual systems and rules and various terms to cover all bases. What's going to happen if this nursing home closes down, where you're going to go, what's going to happen in regards to that, because it's also quite heavily regulated as well.
Would we be able to use Pablo as an example? Say he was a gardener at a Triple L facility.
Yep.
He's signed on for 12 months.
Yep.
After 6 months, he goes, you know what? I don't need to work. I don't want to work anymore.
Sure.
If the Triple L proves that conscience will leave, and they have to go through extra effort to find a new gardener.
Sure.
And he knows that it's going to be detrimental to them.
Yep.
Find someone new.
Yep. The question is, going back to the tute question from this week, in terms of the gardener with the periodic contract for 12 months, where it's been terminated after 6 months, and whether or not it would apply here to have some restriction on termination. Arguably not, because there's no promise that's been made. Here, the promise has to be, hey, we know we have the right to terminate, but we're not going to use it for whatever reason. All right? We like you. We don't want this to blow up. We won't use this right to terminate. Okay, now strictly speaking, remember, it's not a contract. Why? Because there's no consideration. It's not a contract. And estoppel, well, the whole reason why estoppel is a phenomena, estoppel bypasses the need for consideration. That's what it does. It's an equitable maxim that bypasses consideration. It's a handy thing to know in terms of how you guys think about contract law, and it'll come up again when you do trust as well. And so in that situation, there has to have been some promise that was made that was separate to the contract itself, where they would say, we won't use our particular right to terminate. That's where that is. Okay, and there's another area called relief against forfeiture. Legion and Hately, it's a little complex. It was a High Court case, and it involves the purchase and sale of land, and the contract date and the date that they sort of moved in was one point in time, but the thing wasn't actually settled until another year later, or it was supposed to be settled a year later. In the meantime, one side came onto the land, built a house. And one thing the courts did note in Legion and Haley, because you can imagine where the story's going here. They've built a house, and then the thing's fallen through. And so you've got the two sides arguing, at some stage later, about whether or not this particular property is going to be forfeited. And so the courts have this long-standing, prerogative power to provide what we call relief against forfeiture. They don't like people losing their land. They don't like it. And so they've had these powers to use that, although they use them sparingly. And so the courts, in situations, again, where there is going to be some form of grave injustice, and that grave injustice flows from one party having their property forfeited, their real property forfeited, and that can include deposits as well. The courts will, in narrow circumstances, intercede to prevent that. It's not strictly speaking to grant them a remedy, other than to prevent termination of the contract. It's only relief against forfeiture is only to do with real property. Yeah, well, a house is part of land. So when we think about real property, it's the land itself. And in fact, Legion and Haley, they talked about this because once you build a house, it becomes attached to the land and forms part of it and flows with it to the next owner of the land. So it became they call them fixtures and chattels. It's a concept you'll do in Land 1 next year for some of you guys. There's a test for determining how stuck the things are in. And so in that situation, when we use the phrase real property, I mean land and everything attached to land, including buildings. Okay. I did again mention this briefly last week as well, that in order to actually terminate contract, you have to actually have been able to perform. And they call this the ready, willing, and able rule. So that at the time where you can go and use and do this right, if the other side is breached, you have to be able to demonstrate to the court that you could have performed as well. Now, that doesn't apply to, it doesn't completely apply to anticipatory breach. What do I mean by that? If one side looks like they're about to breach contract before the time of performance, the other side sees that and recognizes it, they can elect to terminate for anticipatory breach.
What did that ship do that?
And the propane.
Yeah, the LPG gas.
They were trying to hunt around to see whether they could get the best price. Because it was one of those situations where, look, if they could go and get a better price elsewhere, they were willing to go through and do that. If the other side was going to rock up late, well, we'll give it to them and sue them for damages. And so there in that particular moment, they went and unsolved the thing, and then the other side did turn up, and so then they were trying to work out, well, at that particular point in time, where does it sit in terms of us? Oh no, we didn't elect to terminate, we wanted the contract to be on foot at that particular case, because these guys turned out not to be in breach. And they said, well no, you've unsolved the stuff. You can't turn around and say that you didn't exercise your right to terminate at that particular point in time. Okay, so just if it is a situation before the time of performance, the rule that they use to say it's not strictly speaking that you need to be ready and willing and able, you just can't be substantially disabled. What that means is that you don't have to demonstrate that you were actually able to rock up on the day of performance and do everything at the standard that was required of you. You just need to prove that you could substantially have performed. If you are substantially disabled from doing that performance, then you will fail the ready, willing, and able test. You won't be deemed to be ready, willing, and able. And you won't. Yes?
Sorry. Question
Okay, so there's a couple of things there. The question is, and I'm just going to try and paraphrase that if I can, which is the reasoning behind the doing and performing when an anticipatory participatory breach occurs, and you getting the right to terminate at that point in time. Why do you need to be ready, willing, and able? It seems a little bit silly if you've realized that the other side aren't going to be performing their side of the bargain. And there's a couple of things that flow from this. The main reason is, if you couldn't do what you were doing anyway, and you have discovered that the other side can't do it, and you keep quiet about it, there's an aspect of injustice that happens there, because they're going to be in breach and you're not going to be in breach, and so they're going to have to pay you and you're not going to have to pay them, even in situations where you couldn't have done the thing. And so all that means is that you've got this strange need to be very quiet about your ability to perform in relation to the other side. And so that can create some quite quirky scenarios and situations where you're trying to demonstrate that you could have, that you're trying to snoop on them to work out and see whether they could have done it. And unfortunately, it means there's also an incentive for people to enter into contracts that they could never possibly fulfill, knowing the other side's not going to fulfill it either. And all of these things are really, they flow from efficiency. It's that idea that we want, the courts of ye olde England want people going out in the world, making contracts and upholding their bargains and swapping things, because it's the act of actually doing it. In theory, if you have something that I want, I have something you want, and we swap, we're both better off. We do this many, many, many times, low transaction costs. The world is better off. Certainly, tongue-in-cheek, certainly the British Empire gets to be more powerful as a result. And so that's why these things come about. It's really to do with an economic efficiency thing, to try and stop people from just really using the mechanics of contract law to get what they want without adding value to the world.
So, just to let me clarify. So basically the courts are taking this perspective so that it's practical. They're basically saying, hey, you have to show that you're still in the right to be able to cut us away.
Absolutely. Okay, the question there. The question sense is that there's need to demonstrate that that you're in the right. You're on the right side of history here. Yeah, I think it is. I think it's really about not wanting to manipulate the rules of contract in situations where there was no real and genuine effort on your part. And we want people to be authentic in their bargaining, actually going in to create things. But make note this last one here in Foreign and White, that again, this is a High Court case where it involved, again, another sale for the contract for the sale of land, and there was some necessary permits that hadn't been obtained, and so settlement happened. Both sides knew about these permits that hadn't been done. I think it was a right-of-way. It hadn't been done, and one side called up the other side and said, is this going to be done? And they said, yeah, it'll probably be all right. Wasn't. But neither side thought that the thing was going to happen. So neither side turned up to settlement. So then, well, what do you do then? And there, what the court said is that, look, in going back through the facts, they tried to work out who had told who about the futility of this situation. And so that in the situation where, you don't need to turn up if you know that it's going to be a total waste of time. We don't want people to rock up with the ice creams to the Strand, ready to sell them, knowing that that's just going to be a futile effort. That's not a requirement in contract law. And again, it goes back to being efficient. We don't want people to waste the goods and services produced by Her Majesty's Empire. That's how I know that sense. Okay, second half of this. Sorry, I'm getting a little bit slow, but I'll zoom through this now. Sorry, the font's a little small. So, assuming that you don't want to terminate, you want to affirm instead. Okay, you can do this in a variety of ways. One is to just encourage, hey, carry on. Carry on doing this contract. Yeah, sure, you're in breach. Sure, we don't have to say that we're not going to sue you, because we may still sue you for damages, but we want to keep this contract on foot. You can do that by doing things like paying them, letting them back onto the property to carry on doing work, not contacting them and saying that we elect to terminate at this point. And most importantly is the second here in the Bell group, which is carrying on performing your own obligations. That's going to be a pretty big one. Another one is if you take too long. If you do get the right to terminate, it doesn't last forever. And as such, if you wait sort of 12 months before issuing this right to terminate, the court's going to say that's too far. It's too far removed in time. And again, I mentioned this earlier about Emma. You have to know about it. In order to affirm a contract or to terminate a contract, you need to know you have the right. You can't discover it after the fact and then try and argue, this particular act of conduct meant that you affirmed it or meant that you terminated it. No. You have to know that you have the right to terminate or to affirm. You can't just determine it on the facts itself. The question is to do with how long the time frame is, and it's one of those answers that the courts in common law are, will say things like, it depends on the nature, the size and scope of the transaction. So if it was a contract to build a dam or something similar, and there was a breach at a point in time, but the contract was spread over 10 or 12 years, then a year's delay might not be okay. But if it's a contract for perishables, it's going to be very... Building a house. That's a good question, actually. So building a house, yep. And it's really up to you guys. So if the builder has said they're going to, if the builder, and here this is talking about affirmation. So we've made we'll say that we're trying to determine whether or not they are affirming the contract or not. Let's say we're in breach. Probably not a good example, because usually you're in breach because you haven't paid someone, all right? And they carry on performing. Usually the carrying on performing is going to be the main one. But let's just say, what if they just leave their tools there and then go away, and then we don't pay them, and then they come back a little bit later on, and maybe there's a period of time where they're deemed to have affirmed it, but there's probably other areas. I'm not sure that's a very good example. Trying to think of another one.
So if they just don't keep showing up to build, so you've got a schedule to build,
Yep.
and they give me an excuse why they can't turn up for whatever reason, they're not doing contracts or whatever, they don't turn up on the date, and
Yep.
I'm waiting to see.
Yep.
You know,
Yeah.
sometimes it's going to happen. Is this a building thing, or is this the first time I'm building a home? So
Yeah.
that's what I'm trying to work out.
It's a breach. So it's a breach situation, and so that you're trying to determine at that stage whether or not you're getting the right to terminate. Here we're talking about, well, if you don't say something about it, how long goes by before you lose that right to terminate? So if they've done something, they've missed some sort of delay, and then they've carried on, they've missed a compliance date or something similar, and you let them carry on for another 12 months, that could well be the situation that you've affirmed that, again, particularly in performing. In terms of you with the house, performing it is by paying them. So that we've carried on paying them. We're going to have a hard time going and arguing later on that, we wanted to terminate back 12 months before, because our conduct suggests otherwise.
We have the payments, don't you take out a home loan and you're building a home to pay it all up front?
It depends. If people can source funds from all over. Okay. Party with the right to terminate is deemed to affirm if they act in a way which is unequivocally demonstrates an intent to confirm. So if you were doing things in regards to this contract, and again, a good example was Amanda's example with the builder, if you carry on paying the person, if they've done a breach, the conduct clearly suggests that is to carry on. Please carry on. Conduct will deem that to be an affirmation. But two things that don't count. One is granting an extension of time. By default, just saying, hey, builders, you haven't met this particular point in time. How about we'll just push it back another 3 months? How about we'll push it back another 6 months? That will not amount to affirmation of a breach. That is not, you're not going to lose your right to terminate if you grant an extension for performing a particular condition, or where there's a serious breach of a professional warranty. That's going to be fine. And another situation is where, and again, this is a bit of a rough stretch. There's in situations where you try to pursue alternative remedies, and so here Johnson and Agnew involved a conveyance of the sale of land, and there was a sale, all right, and the vendor, so the seller, was a bit short on cash. All right, and so the thing was going to fall through. The other side was going to be in breach, and so he was wanting to seek specific performance. Now, specific performance is a remedy. It's a special remedy in situations where the thing that's sold is unique or special. It means basically to make someone convey land in that situation. It's only used in narrow sort of circumstances, usually to do with land. We'll talk about that in about 2 or 3 weeks' time. But there they tried to argue that because there was specific, trying to use specific performance to convey the thing, that amounted to affirmation. And the court said no. Specific performance is just a remedy you can get an alternative to damages. That will not on its own constitute affirmation of the contract. The guy wanted to convey the land, right, and wanted to get the courts to try and do the thing, because specific performance will make the other side take the land. And look, he was going to have a hard time finding another buyer. That was the main reason this came up. But the person who was selling it needed to sell the land. He needed the cash. He was short. His finance had fallen through, and he needed to do it. And he got a buyer, and the buyer was in breach, and so that they was trying to get specific performance, and then later on they came to have this argument where, well, was that seeking specific performance, was that affirming the contract? And the court said no, it's not going to be in that particular circumstance. Doesn't count as affirming the contract on itself. Again, usually in situations where they've gone, they wanted the person to convey the land because they couldn't find another seller. All right, and then later on, that's fallen through, but then somebody still wanted, because remember this affirmation. This here, one side is trying to argue that wasn't affirmation. The other side is arguing that it was affirmation. That's right, but the court say that, look, just going and getting the court order for specific performance isn't going to count. It's not actually going to affirm the contract. Doesn't mean he loses the right to terminate for breach in that situation. Because then later on, when he realized, oh wow, we go to seek specific performance, oh look, this purchase is a bit of a disaster. And so then the purchaser has carried on and said, oh no, okay, we've waited a little bit of time. Yes, we'll still buy this after all. And then the guy's got, oh no, I found a better seller, a better person to sell to. You were in breach. I don't want to affirm this contract. And they've said, well, seeking a remedy in specific performance, trying to do that's going to affirm. And the court said, no, it's not. No, seeking specific performance is not going to be sufficient.
What if he actually gets it?
Well, if he gets specific performance, then the problem's over. The land's being conveyed, and this won't come up because you can look. You'll still be able to see damages, but it's the right to terminate at that time. That's right. Yeah, that's right. Yeah. Chocolate traders, yeah. Extensions, yep.
No, the comments section.
Yeah, Simon's. What case is this one? What case is this one? Simon. Oh, sorry. I'm not sure. Sorry, Karina. I can't work out which case you're referring to.
It was the one you just put down there.
Johnson and Agnew. It's a UK case. Johnson and Agnew. All right. So, I guess kind of logically, when a contract is affirmed, all rights stay on foot. the contract is still binding on both parties. And if you do choose to affirm the contract, you lose that right to terminate, but you can get it, it can arise again if another breach happens. And the right is reacquired. And also note that if there's repudiation or anticipatory breach, in other words, before the time of performance, one side demonstrates an unwillingness and inability to perform either all of the terms, contractual condition, or a series of warranties, and it's before the time of performance, and you determine to affirm that, and then they rock up at the time of performance and they still don't perform, you reacquire the right to terminate. So those are two separate instances where you get the right to terminate. Yeah. All right, what we'll do now, that's the end of the affirmation and termination. It's the election component, so it was a little bit more in depth than last week, but I'm going to switch the streams, change the projectors. We'll take about 5 to 10 minutes, then we're going to come back to about the doctrine of frustration. Okay, thanks team.